Yes, good evening to everybody. Welcome to the Law of Tort class, and today is the second class of online. And please read what I posted on the screen. Anyone can unmute and read. Click.
Essential elements of tort.
There is a good evening is there. Law of Torts, essential elements of tort, notes, case class, and study material. Below, Professor Dr. Mohammed S. Hussain Saheb Hussain is there. Is it or not? Okay. Now, see, in my last class, I was dealt up to certain extent. There I kept a mark also. I would like to go to the mark because I want to find it, how to make it out. Why it is not coming? I say find. Okay, it's not coming. But okay, directly I can go to the place where I stopped. Essential, there I stopped. Where the essentials are there I stopped. Yes. See here, this mark that I would like to go over there. What is this? Is it a sign or symbol? This one. Anyone?
That is a symbol, asterisk symbol, sir.
Is the asterisk? Is it a sign or a symbol? It is because there is a difference in the symbol and a sign.
It is a symbol, sir.
Okay, very good. Then I would like to show this thing. I believe that you could also make it out. What about this one?
That is ampersand, sir.
Yeah, the other people, you give the chance to the other people. Next, what about this one? Click.
Therefore.
Very good. What about this one? Click.
Apostrophe.
Yes?
Apostrophe.
Apostrophe. Apostrophe is only single is there.
Double apostrophe.
It is not a double inverted comma also. Nazmin. It is not a double inverted comma also. Anyone? You say the person, I will give the answer. Don't waste the time.
Sir, inverted commas.
No.
Ditto, sir. Ditto.
Yes, I appreciate. It is a ditto. Yes, next, what about this one? Click. If you don't know, you can just say pass on.
Similarly.
It is the tilde, T-I-L-D, tilde. Where the tilde has a specific meaning in mathematics, programming, and the Spanish, Virgil Portuguese. In English, it is a common use. It means approximately, usually before a number. See, born approximately tilde 455 AD. Let's meet approximately, there is a tilde 15 minutes before that, because these sign symbols are there where we can use it in our language. Now, without wasting the time, I would like to come to the point of our study is concerned. Yes, the essential of a tort. See, whenever you're writing the side headings, these are called side heading. The side heading never ends with any punctuation. That is a rule. Essential of a tort. Of is the preposition. A is a
Article.
preposition. A is an article. TOT tort is there. And here, when you are writing it, always keep in the mind all the first letters should be the capital letters except the prepositions and articles, the side heading program. That is the rule, writing rule. Okay, these are the two essential to commit a tort. Number one, either the act or omission. Either you do an act or omission to make a person liable. To make a person liable in tort, he must have committed some act or omission, both the things, in the performance of his legal duty, where a legal duty would be imposed on him. For example, entering someone's property without any justification or defaming a person of his reputation. These are acts result in the tort of trespass and defamation both. It is the act of trespass and defamation. What is trespass? Anyone? Quick.
Unauthorized entry.
See, I already put on the screen. By looking at also, you can entering somebody premises without any legal justification is a trespass. And making an allegation over a particular person is a defamation. Are you following me? Say yes. Are you
Yes,
following me?
sir.
Yes. Suppose in the bank, then would you have a very good case law? That is the Shama Devi case law. If I not be mistaken, the defamation when I am going to teach, I will teach you that a customer or a client went to the bank where the bank staff addressed to the customer, the client, or the, what is the appropriate word for the bank people? What is the appropriate word? Can you say customer? Can I say client? What is the appropriate word? If you don't know, you say pass on. I will give you
Customer.
answer.
Customer.
Customer, sir.
No.
Account holder.
Account holder. I appreciate. That is the appropriate word. Don't say the customer, client. You say the account holder is the very appropriate word over there. Where the staff member has addressed to a woman, that is a lady, the account holder, you are a prostitute. You are a prostitute. Merely the verbal is enough. It is amount to the defamation. And we can bring an action against the staff of the bank. I think that is the State Bank of India. That is the bank, if I am mistaken. Okay, we can bring the action against the defamation over there. So it is an act because she did something. She uttered something. And he trespassed. He passed it in somebody's land without any justification. Yes, it is a trespass. So it is an act. Now let us see what is the omission. Omission. See, we have a beautiful case law. That is, I don't know whether you remember the case law. Glasgow Corporation versus Taylor. Omission, that is. Can anybody will tell me that case law? Sir, we don't know, sir. Of course, the seniors don't know it. If they are present, they could definitely tell. But that case law will give you the explanation. See, it's a botanical garden which is open for the public. And where the children also entered over there. At that instance, I believe that everybody knows cherries. Cherry. 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 Which looks like the berries. The cherries will be there when you take the pan, mita pan, the cherries will be kept over there. So, there are some poisonous plants are there, which are actually the name is belladonna. The name is belladonna. But it looks like a cherries. So, there is no caution board, number one. There is no fencing around the bush. So, a child thinking that it is a cherry and he plucked it and eaten, and consequently he died. Because of it's a belladonna, which is a toxic substance. So, he bring an action against the botanical garden, the public garden which is maintained by the municipality or any other authority is concerned. Then they say the omission of the duty they did it. What is the omission of their duty? What is their omission of duty?
Cut off
I told
the
you.
fences, sir.
Number one,
Fences.
they did not keep the caution
Not
board.
cutting the
Number two, there is no fencing. Because when a tree is a dangerous thing, it should be fenced. Number one. Number two, there should be a caution board also. Let's say a poisonous tree. Don't pluck either the fruits or the bark or the leaves, anything. They should keep a caution board, and that to be the language known to the people in the particular place. So that is the omission of the duty they did it the corporation. Hence, it is also either the act or the omission. In both the way, it will be a tort. Is it clear? So that is the reason. To make a person liable in tort, he must be committed some act like a trespass or a allegation made over a particular account holder is a prostitute. Can you tell me another name for the prostitute? Anyone? Hurry up.
Sir, call girl, sir.
It is a common word. The call girl is a common word. Professor Hussain students will not say call girl or the prostitutes.
sir, extramarital affair, sir.
Yes?
Extramarital affair, sir.
No, that is external affair. You are giving the explanation. Harlot. 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 Well, that only the professors and students will say like that. Okay, if you call a woman as a harlot, then it is a motive defamation, it is an act. But you did not give the fencing, you did not give the caution board, that is the omission. Even when you go for the mall, means super bazaar. Mall means supermarkets, where the janitor will clean the floor, and when the floor is wet, he has to keep the caution board. What is that? Floor is wet, take the diversion or take care. Or in the road, we will keep it the caution board. Work is in progress, take the diversion or go slow. Did you see such a caution boards? Yes?
Yes, sir. When the
Yes,
work is
yes.
going, while work is going, it will be seen, sir.
Yes. In the electrical transformer, there is a caution board is there. What is the caution board?
Dangerous and high voltage.
Okay. In in other sense, a sign and a symbol also there. They use it. Perhaps the symbol they will use it. No, better sign, because sign also conveys something. Warning. Warning is a sign. Symbol means H2O is a symbol. CO2 is a symbol. Carbon dioxide. One skull and two crossed bones. What is that?
Danger symbol.
Danger symbol, that is. Okay. So now the number 2, legal damage. When say legal damage, to be successful in an action for the tort, the plaintiff has also to prove the legal damage or an injury. An injury is caused to him and legal damage should be there. Unless there is a violation of the legal right, there should be a violation of the legal right only there. Then only that injury will counted as an injury. And an action under the law of torts cannot lie. If there is no legal injury, then there will not be any tort at all. So now let us see that legal damage are of 2 types. Legal damage, how we can make it out? There are 2 types. Number 1, injurious sine damnum. It means injurious sine damnum. It means a violation of a legal right without causing any damage to the other person. There is a legal right is made there, but there is no injuries, harm is not caused to the person. Since there is a violation of the legal right, it is actionable even without the proof of damage. If it is a legal right is violated over there, even though there is no substantial damage or any damage caused to him, still it is actionable. So a landmark case law will help better understand this principle. The landmark case law in this read Ashby versus White, where there is a legal injury is caused, but we know damage is occurred over there. So that is the case law is Ashby versus White. Number 1, in this case, what happened? The defendant, a returning officer, in a election wrongfully refused to take the vote of the plaintiff. The plaintiff actually his name is there in the voter list, and he is really having the franchise to vote, but the list which is carrying the returning officer is not updated. The old list would be there. That's why he could not see the VKD. You want to speaking somebody else, because I could see the caution there. Speaking VKD. You mute it. You mute it. VKD, you mute it. VKD, participant, you mute it. He's not muting, he's speaking. You have muted all attendees, yes, because he's speaking to somebody else. Please, when you speak, you unmute it. Otherwise, you can mute it. So, in this case, what happened? He is having the full right to vote, his franchise, but his name didn't appear. And because he is maintaining the returning officer, maintaining the old list, not updated list, the plaintiff did not suffer any loss because he did not allow the plaintiff to, who did not allow, returning officer did not allow the plaintiff to cast his vote. And with that, but to whom that he would like to vote, he won with the bumper majority. But he said, the legal injury is caused to me, even though to whom that I would like to vote, he won with the bumper majority also, doesn't matter. But my legal injury is caused, even though there is no substantial damage happened, because to whom that I am going to vote, he won with the bumper majority. Even one vote cannot make any difference to him, but he is not the loser. The defendant was, however, held liable because the plaintiff legal right had been violated because there is a negligence in the part of the presiding officer or returning officer not allowing the plaintiff to cast his vote. There is a legal injury is caused even though there is no substantial damage or in damage caused to the plaintiff. Did you get my point? That is called Ashby versus White is a remarkable case law which will be come under the injuria sine demno. A legal injury is caused without any damage to the person, without any injury. So that is the one of the case law. Of course, such case laws are at least 3 or 4 are there in other books. But now I have given only sample of the case law. But when the reference comes over there, then I will can give them more cases also. Okay, now let's come to the demno sine injuria. Means damage is caused substantially, but there is no legal injuries caused to the person. In such a case, no action could be there. It means causing damage without the infringement of the legal right, unless there is an infringement of legal right, the violation of the legal right, the breaking of the legal right, mere causing damage is not an actionable. So here, the landmark case law is, everybody knows, Gloucester Grammar School case law. Gloucester Grammar School case law. Can you tell me the grammar spelling, please, anyone? Unmute and give me the answer.
G-R-A-M-M-A-R.
Grammar. That is the right way of saying grammar school. So Gloucester Grammar School case law, in this case, the defendant set up a rival school to that of the plaintiff. Actually, they are both the partners are there. The school is running very, very high fees, very good. Is a roaring type that is running, and later on there would be conflict with the two partners. So one of the partner came out of the school, and in the opposite he opened another school with a slight different name. With a slight, if the Gloucester Grammar School is there, he can keep the new Gloucester Grammar School or something like that. He opened it in the front of it, but he kept a good staff, a good infrastructure, and everything is good. Moreover, the fees also very much less when you compare to the earlier school. So because of the competition, the plaintiff had to reduce their fees for the 40 pence and 12 pence per the scholar per quarter. It was held that the plaintiff had no remedy for the loss thus suffered by them. Because when he has opened the rival school opposite one and he reduced the prices also, moreover, the many people from the former school took the TC, transfer certificate, and joined in the new school. Because number one, good staff. Number two, good infrastructure. Number three, a lesser amount of the tuition fee. So now the former school has suffered a financial loss substantially. The revenue goes down, and now he is the position of the insolvent or going to be corrupted over there. So he brought an action against the person who opened it because of his school that I suffered the loss. Then the court observed that it is a legal injury is caused. No, there is no legal injury, but the substantial damage is occurred over there because in business competition is allowed. Am I right?
Yes.
So that is the reason they say there is no legal injury is there, even though substantial damage is caused to the person, because most of the students left the school and joined the other school, and the substantial damage for the fees in the form of fees happened to the former school. But there is no legal injury is caused, even though substantial damage caused to him, but there is no action in the tort. So whether the mental element is of any relevance in tort or not. So generally, under the criminal law, mens rea, that the guilty mind is necessary element for liability. But the same is not the case with the law of torts. Whether he is having the guilty mind, whether he doesn't have the guilty mind, whether his son has thrown the stone on the windscreen and the windscreen is broken, or it is totally, completely, it is fractured, number one. Number two, completely broken into the pieces, but pieces attached to it, the windscreen, but is no more used to use it. What is windscreen? Yes?
Front and rear view windows, sir. Glass doors.
Window panes are different, windscreen is there. In the car, the front one is windscreen, the back also the windscreen also there. So the front one is generally set to be the windscreen, even including the back also. But the panes are different, and rear mirrors are different. So a student, a boy, a naughty boy throwing a stone on the windscreen, the windstreak is broken. At that instance, who will be held liable? Sir, a small boy is no, sir. He will say that 2 times excuse. Okay, if you want, he can take say 10 times excuse. Or if you want, he can make the 6 and down also. But who is going to pay for the damage? Yes. Whether he is having the guilty mind or no guilty mind, that he suffered the damage. Then a father, a son or a child will be identified by the parents, means father. The vicarious liability come into the picture there. The father should have to pay the compensation, either to buy the new screen or give the money to him to replace it. Am I right?
Sir.
Whether it is a mens rea or not, we don't count it in the tort. The damage it happened enough. So torts such as assault, battery, false imprisonment, deceit, malicious prosecution, conspiracy requires the state of mind of a person and are relevant to ascertain the liability, while torts are such a negligence or defamation don't require a mental element, and that is completely irrelevant. So mental element in certain cases we don't consider it, whether it is a mental element or not, guilty mind or not. In the same way, bad intention, good intention also sometimes we don't consider it. But in some exceptional cases, we will consider it, whether the intention is good, whether the intention is bad. We do have at least 3 or 4 case laws are there, whether intention is relevant or whether intention is not relevant in the law of tort. Generally, intention is not relevant in the law of tort, but in certain exceptional cases, intention is relevant. We have a beautiful case law that I could remember, the Hollywood Silver Fox versus Emmett. I don't know how many people studied it. Of course, how many classes are done, I did not know because we are the first years. How many classes that you attended till now? Anyone? I'm speaking to the first years.
Only one class.
Only one class. I am not speaking about the online classes. You are somewhere you are joined as a student, is it or not?
Yes.
How many classes are conducted over there?
There also only one class over, introduction class.
Okay, introduction class. That's why you don't know. But I am giving you a advanced Hollywood Silver Fox versus Emmett case law. That is very much important, where the intention is taken into consideration. I don't know. Do you know fox? Fox, F-O-X, fox.
Yes, it's an animal.
Yes, sir, it is a animal.
It is an animal, no doubt. Fox is intelligent, highly intelligent.
Too intelligent,
It's
sir.
clever,
Too
not
much
intelligent.
Fox is very intelligent, sir.
Too much intelligent, fox is. So, fox is a masculine gender or a feminine gender? If you know it, you
Sir,
tell me. If you
masculine,
don't know
sir.
it, you say pass on.
Masculine gender, sir.
Then what is the feminine
Masculine,
gender?
sir.
What is the
Vixen,
feminine
sir.
gender?
Vixen, sir.
Vixen, you give the chance to the juniors. Okay, don't matter. Vixen, V-I-X-E-N, vixen. So, there is a breeding season for the animals. In the breeding season, if anybody make any sound, they could not breed. Means copulation would not be there. At that instance, the offspring will be very much low. Means pregnancy of the vixens will be very much less when there are a lot of sounds are there. So here, Hollywood Silver Fox versus Emmett case law, the neighbor intentionally in the breeding season, he is firing the gun in the air without any reason. Without any reason that he is firing the gun. And he's saying that I want to practice it. Okay, you can practice it, but you practice in the daytime. In the nighttime also he is doing so. So they said, you are not supposed to practice such a thing when the breeding season is there of the vixen. That means you have an intention not to increase the frequency of the vixens. That's why you are causing such a disturbance over there. So your intention is bad, and hence intention is a relevant factor over there. And we do have another case law also. I believe that case law name I have forgotten, but I can easily make it out. What is that case law? Because if I type it in the Google search engine, it will definitely tell me what is the name of the case law, because I know the facts of the case law. The facts of the case law is music teacher. He is a music teacher and he is giving lessons or giving tuition to the student, but neighbor man disturbing his class, and the name of the case law is, see, I'm showing not only the thing, I don't know, hoping you will get it or not, teachers. Here, I did not get it, the name of the case law, but when you want to say the no tort law, no case law, no tort law. Please note the point. No tort law, no case law, intention is relevant in law of tort, decided cases. We have cases because I could not remember the case law, but I will have to give you. Whether the intention is relevant or not. Role of intention in fixation of the tortious liability. Yes, I believe that we will get some of the cases here, whether the intention is relevant or not. Okay, but I will give you only the explanation now. See, in that a music teacher is giving the lessons to the students as a tuition, but the neighbor fellow intentionally disturb the music teacher classes. He is beating in his kitchen all the utensils and causing an unrhythmic sound. And the teacher classes are suffered because of this sound. Then the teacher approached to the court, sir, when the class is in progress, this fellow is beating the utensils. That fellow said, no, I'm cooking, sir. When you're cooking, could you, okay, one time that even a plate will fall down, but not all the time, is it not? That means they say, you are creating the nuisance over there, you are causing at the time of the classes, that means intention is relevant over there. So in certain cases, intention is taken into consideration, but in some cases, intention cannot be taken because either you have the intent or may not have the intent. Whether you have the intent may not have the intent, but you have beaten that fellow, that means you are a trespass to person, you made assault, hence you will be held liable. So that was the thing generally will come across when you are dealing regarding the intention. So now let us see the type of the damages. Of course, we do a special chapter there in the damages. There we can give the in detail what the type of the damages are there. But here for the time being is a sketch, nominal damages. In the situation where there has been a breach, please, Sanjarani, you mute it because I'm getting the sound from your side. Yes, nominal damages in the situation where there has been a breach, but the non-breaching party has really suffered no loss, can prove that what his loss is, he is entitled for the nominal damages. See, in the case of the Ashby versus White, if you happen to see the case law, the entire case law, nominal damages are awarded in the Ashby versus White. The reason is, there is no substantial damage or any damage happened to the voter because, tell me, because, anyone? Because to whom he want to cast his vote, he won with the bumper majority. At that instance, there is no damage is happened to the voter. But his legal injury is there. What is the injury? He is having the right to use his franchise where the returning officer stopped him to not to use that franchise. So that is the legal injury is caused over there, and hence a nominal damages are awarded in that case. Agreed? In the nominal damages, we have another case law also. There is, but just I have forgotten the name of the case law. But when I come, I will give the name of the case law later. Now, next is compensatory damages. These damages are paid to directly compensate the non-breaching party for the value of what was done or performed or compensatory. See, whatever the equivalent amount will be there, that much amount will be paid in the to compensate the loss. So that would be the compensatory damages. And the punitive damages, And these are also said to be the exemplary damages or damages in terrorism also we can say. And we do have a beautiful case law under the exemplary damages or the punitive damages. That name of the case law is Bhim Singh versus State of Jammu and Kashmir. That is a very remarkable case law where we can say a MLA who wants to go for the legislative assembly where the police high hand is not allowed that fellow to get into the assembly sessions. Then he was detained, but later on he was released. But he filed a case under the habeas corpus number 1, number 2 false imprisonment, and the state, the Jammu and Kashmir, the state which is running the police department, the state would be held liable to pay the Bhim Singh around about 50,000 as a compensation. The exemplary damages are imposed on the state, so that state would not dare enough to do such an act again. So, of the high-handedness of the police. So, exemplary damages are awarded over there, which is said to be the punitive damages. And contemptuous damages here, with the forcefully, the court will say that, okay, we are not going to give it, but anyway, that a little thing up, reluctantly awarding the damages are called contemptuous damages. So trivial nature would be there. It is only wasted the time of the court. The court awarded a mere amount to the plaintiff as a damages because anyway that fellow has approached it, but actually the trivial. I don't know whether you know it. Before the fountain pen, how you used to write? Yes. What is
Ink pen, sir.
Pardon?
Ink pen.
I said before the invention of the fountain pen.
Feather.
Yes, what there is a particular name for the feather.
Quill, sir. Quill.
It is a quill. Q-U-I-L, quill. They used to use Srinivas Macharla. You mute it because once given the answer. Okay, it's called quill. Q-U-I-L, quill. They used to dip the quill in the ink pot. Then they have to write it. Suppose if you dip the ink in the ink pot of somebody else without taking his permission, it is amount to stealing. No doubt it is stealing. But I told you yesterday in the class, small stealing is called, yes? Small stealing is called, in yesterday class I already told, at least many places. You're stealing in the villages by keeping the two hooked wires in the night and using
Offense.
electricity.
Offense.
Yes?
No, sir. Pilferage. Pilferage.
Pilferage, appreciate. Pilferage, Pilfirage. Even though it is a pilferage, can you go to the court of law for getting the compensation without my permission that he dipped his quill in my ink pot? Suppose he was there, he would have to ask the permission, but he was not there, he did not ask it. Moreover, how many drops that he used? Only 1 or 2 or 3 drops. For this is a trifling, but anyway, contemptuous damages means reluctantly the damages are awarded because the plaintiff approached the court. So in the conclusion, I would like to say that the law of tort imposes a duty to respect of the legal rights vested in the member of the society, and the person making the breach of duty is said to have done the wrongful act and penalized under this law. And here the penalized is nothing but the compensation. The law of tort is mostly used in countries like the USA, Canada, other, while India uses only a part of which the Consumer Protection Act, even though Motor Vehicle Act also we can use it. Are you following me?
Yes, sir.
Yeah, these are the things which I come across. But I would like to show some of the distinctions between the two which are there. I would like to say, and I put it over here. I don't know where I could put it. I put all those things here. Okay, just a minute. Please, when you speak, you can unmute. If not, if you don't speak, please mute it because I'm getting the sound. Drumming sound or I think. Yes, here I could see some of the differences between the tort and crime. I'm sure that you could see the screen. Is it or not?
Yes, sir. Yes, sir.
I appreciate. Now you mute it. So let me see the comparison chart, basic for the comparison meaning. Let me see the meaning of tort. When they see the meaning of the tort, somebody will take the snapshot because now the participants are 35. Yesterday participants are 34 because one has increased more today. So now, torts implies a wrongful act causing injury or harm for which recovery is sought by the aggrieved party as per civil law from the person who is responsible for the act. Because it is the meaning is clearly say it is a wrongful act causing the injury harm to recovery set up by the aggrieved party as per the civil law, and the wrong caused is also if the legal injury should cause to him. That is the meaning of it. Whereas as crime is concerned, crime refers to an offense or wrong. He say either is offense or wrong or illegal act. You can say both the offense or wrong or illegal act for which the person conducting it means doing it will be punished under the court of law. Yesterday I told you that a person, a wrongdoer is called tortfeasor in the tort, but where a wrong illegal actor doing person is called perpetrator. Repeat, perpetrator. Okay. Nature of law. It is a tort is uncodified law, but the crime is codified law. Example. Yeah. That is Christie versus Davy. That is the case law, the music teacher case law. Yes. IPC is a codified law. Involves infringement of the individual rights are involved in the tort. But in the crime, it is the violation of the public rights. The public law will be affected. So hence it will say in that way. Regarding the court is concerned, the defendant will be sued in the civil court. But where the crime, the defendant will be prosecuted in a criminal court. What do you say the criminal court in district? Anyone? Sir, criminal court only, sir. Sessions court. That is the right word. It is a sessions court, we will say. The same district magistrate would be there. He will deal the civil cases and he also deal the sessions cases. Of course, they will fix the dates or days to deal the cases. Okay, objectives. To protect the right of a person here. Means individual rights are protected in the tort. But here, to maintain the law and order in society and prevention against the crime and punish the wrongdoer. Who is the wrongdoer here in the crime? I told you, the word starts with the P. Yes? I already told in just before. Perpetrator.
Sir.
There is the wrongdoer called perpetrator. That is the wording they used. Regarding the comes to the matter of the remedy is concerned, on being liable, the defendant has to pay damages, virgule, compensation decided by the court. So here, what is the remedy available in the tort? General remedy available in the tort is damages or compensation or money. But no incarceration, keeping behind the bar. But in the crime is, on being guilty of the offense, the defendant will be sentenced. Sir, what is this sentence, sir? Grammar sentence, sir, it is. What is meant by sentenced? Pronouncing that he would be behind the bar for the 3 months or 1 year. Such a order will be set by the competent judge is called sentence. He is sentenced to 1 year, 7 years as a punishment to stay in the
Prison, sir.
prison. Not stay in the garden. So that is called sentence. That remedy would be there. And in addition to that one, especially in the jurisprudence is changed over there for the rape, because if the fellow who is the perpetrator, rapist, is a very much sound man would be there, and there would be a stigma on the part of the victim to remove such a stigma, and the court will also award for the damages in addition to the incarceration, that is the punishment. So the jurisprudence is now changed, especially certain crimes. The perpetrator, the wrongdoer, should have to give the money as well as he should undergo the imprisonment. So that is the remedy is now available now. The standard of proof is concerned, the balance of probability is also known as the preponderance of evidence. So here, based on the preponderance of the evidence would be there in the tort, but beyond the reasonable doubt would be there in the crime. Because what is the beyond the reasonable doubt theory? Let the 9 convicts will be released, but one innocent cannot be
Punished.
punished or convicted. So that is the beyond the reasonable doubt is there in the crime, but when it comes to the matter of the tort is concerned, it is the balance of the probabilities, also known as preponderance of evidence. It is the individual interest and it is a group interest. So burden of proof is the burden of proof rests with the claimant who wants to claim the compensation. But when it comes to the matter of the rest with the prosecution, here is the prosecution. Who will run the prosecution? Who will run the prosecution? Who will move the prosecution?
Public prosecutor, sir.
State. You say state, no doubt public prosecutor. There APPO is there, assistant public prosecutor, police prosecutor is there, in the GP is there, for the civil cases, government pleader is there, different people will be, not elected, no, nominated, recruited for that tenure, the 3 years, 5 years tenure would be there for that. But when you come to the matter of the public prosecutor and assistant public prosecutor or the police prosecutors, and these are permanent in nature, through the, yeah, I think PSC will conduct it, if I not be mistaken. Am I right? Yes? Or the,
Yes, sir.
yes, for the magistrates, either PSC or High Court, who will conduct the magistrates exams? Because as per the education is concerned, to my knowledge, the TSPSC will conduct the junior lecturer post or the lecturer post and so and so. For the board of intermediate, of course, education, they will take care of it. Of course, DUO and other people will take care of that in the education of the lower level. But in the higher level is concerned, from the junior college to the degree colleges or the universities, it is the university individual, they can make the recruitment. In some places, the government colleges, it is the PSC will review the recruitment for the junior lecturers as well as the senior lecturers or the degree college lecturers. Of course, now that sometimes now it will change. Sir, there is no question of recruitment now, sir, in these days. The question is different, whether recruitment is there or not. But who is the body who will make such a recruitment? That's my question. So these are the certain things which I want to share with you. And now still we do have some 2 or 3 minutes will be left over there. But meanwhile, if any question that you would like to ask me, you can ask me. Because last class somebody is asking, sir, in the PPT some bracket is there. Can that person is now present? Could you repeat the question? Whether the person who asked yesterday, whether he is present now, sir.
Yes, sir.
Yeah,
Sir, this is Satya. Yeah. Yesterday, I was asked in your Word document presentation to
Yeah.
inside the bracket there is a small m. So how to pronunciate that?
Small
M.
N.
M.
Could you chart
M
it?
for Mumbai.
N for number. Yeah,
Mumbai.
Yeah, NUMB or number.
Mumbai.
Achha,
M for Mumbai.
M.
Okay.
Small m. Where
Yes,
it
yes.
appears? Small m, where it appears?
2 inside the bracket.
Can you chart it and show me? In the chart, could you show me? I would like to see what you want to say. In chart, you can show me. Because I could see your chart. Quick. Oh. Achha, you want to say the section reading. See, in the General Class Act, only the definitions comes in the section 3. But in all acts, definition comes in the section 2. You take, for instance, you take the Contract Act. They don't say definition, they say explanation. So whenever such a thing comes, I will give the example. Whenever such a thing appears over there, this is the way of reading it. Okay, I will give the example here. For instance, yes. Let me give you the example here. Section, you say section here, like if, for instance, given like this. Yes, now how do you read it now? Now you tell me, anyone. But I will read it. The time is going to up now. Because section 4, subsection 1, class A, para, capital A. Para, capital A. Section 4, subsection 1, class A, para, capital A. This is the style of reading. Any doubt? Any doubt?
Sir, once again read it, sir, please.
Yes?
Once again pronounce, sir, section.
Section 4, subsection 1, class A, para, capital A. So I
Thank
say
you, sir.
capital A. Please note the point. So this is the style of writing and reading it when it crosses over.
Thank you. Thank you.
Yeah, but after para A, there may be some proviso also comes in statement. Proviso, then you read the statement. Because generally, certain sections, the subsections are in the proviso also there. So the style of writing is, this is the matter. But when you see the section, especially the definition, each definition clause is an independent clause. That's why there's no connection would be there. That's why instead of saying subsection, we will say clause. Because under
So,
yes.
sir, so I can read this one as a section 2, clause M.
Yes, small n, clause n.
Yeah.
Yes.
Yeah. Okay.
But
Thank you.
don't say subsection n.
Yeah. That's what.
No,
Okay. Thank you so much.
because in definition, each clause is an independent clause. There is no connection at all. If you want, I can show you, but the time is going to up now. Each clause is a independent clause. For instance, you take the law of contract case law, but it is closed. It will be closed now. I will show you that law of contract. Suppose it is the, where it is the law of contract. Yeah. See, I opened it. If you happen to section 2, okay, directly, there are many sections are there. See, I go to the section 2. See, in the section 2, we don't say definition, it's a interpretation clause. See, there is a tail is there. This is a tail, but small a is there. This is an independent clause. This is an independent clause, A. See, B, independent, nowhere connected with the C. C is different and B is different. For instance, you read, when the person to whom the proposal is made signifies the assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Over. But no person making the proposal is called the promisor. This is different, this is different. That means each clause is an independent clause. That's why we